Joining me this morning is Mark Chenoweth. Mark Chenoweth is with he's the president of the New Civil Liberties Alliance. And Mark, welcome to the show. Glad to have you.
Good to be with you, Jim.
Okay, now, I've always said that Democrats love democracy as long as the vote goes their way, and if it doesn't, then they go to the courts, and if they don't get their way in the courts, they just pretend the court decision didn't exist and do it anyway. Now, recently, the Supreme Court said that Joe Biden forgiving, well, by the way, Joe Biden's not forgiving anything. You are. You're going to pay for it yourself. This idea of forgiving student loans was unconstitutional, and so they turned around and did it anyway. Can you explain that?
It's pretty hard to explain. I think that the Supreme Court was quite specific in saying that, look, if you're going to have something of this scale, then you really have to have explicit statutory authority to do that. And the administration had pointed to something called the HEROES Act, which was a post 9/11 piece of legislation intended to forgive some loans of people who were called to active duty and maybe couldn't make their student loan payments anymore as a result of drawing a lower salary in the military than they had been drawing in whatever private sector job they had before. That was really the main point of the HEROES Act. And the court said, no way, that you cannot read that legislation to forgive $500 billion in student loans for everyone else. Or what they were actually doing was forgiving $10,000 or $20,000 rather arbitrarily of student loans. So now they've turned around and said, oh, well, if you don't like that statute, how about this Higher Education Act? And so that's where we are now.
Well, how do they figure that the Higher Education Act gives them the authority to do this?
Well, the Higher Education Act contains language that, once again, much like the language in the in the HEROES Act, is what's the best way to say it? Is either sort of vague, or you could make an argument that it gives some general power to the Secretary to compromise loans, forgive loans. But the idea behind it is, look, if on a case-by-case basis, the agency wants to engage in negotiations with individuals, and maybe someone's in dire straits, or maybe the Secretary figures, look, we're never going to get the $10,000 that this person owes, but here we have an opportunity to compromise the debt with them and get maybe $5,000, $6,000, $7,000, and the government will do better by getting this than it will by just sitting around waiting for its 10. Then there's this negotiation authority that has been given. That is not blanket authority to engage in some sort of blanket forgiveness program or to essentially write new law, which is what they're doing whenever they come up with these criteria for who they're going to forgive loans to and how much and so forth. That's legislating. That belongs in Article 1 of the Constitution, says that belongs in Congress.
Right.
That's not the authority that the Secretary of Education has been given.
You know, it's funny. You listen to people on The View, and they all talk about how Donald Trump is a threat to our democracy and to our constitutional order. And yet at the same time, you got Joe Biden. This guy is acting like a dictator. He's just doing stuff because he wants to do it. And basically, I guess they're saying, sue me. Now, are you? That's my next question. Yesterday, there was a virtual public hearing on this. I know you were involved in part of it. Tell us about what happened there, what you observed.
Sure. So what they're engaging in negotiated rulemaking, which is a somewhat lengthy process and is a somewhat unusual process as well. And so as part of that, they called this hasty public hearing. It didn't really give very many people the opportunity to know about it ahead of time or to prepare much. But we heard about it and said, well, look, they're going to give me the opportunity to speak my mind for 4 minutes. I'll take advantage of it and tell them what they're doing wrong. So I testified yesterday morning, and one of the things I focused on, because I figured no one else would, is there's something called suspending and dispensing power. And that's a little bit in the weeds, But essentially what that means is there is no power under the Constitution anywhere for the executive branch to say the law applies to you, but it doesn't apply to your neighbor. That was something that the kings used to do, right? If you were a favorite of the king, then he would suspend the law as it applied to you. And this sort of dispensing power is something that the American colonists were fed up with. They wanted nothing to do with. And our Constitution does not give the executive the ability to pick and choose who the law applies to. But that's essentially what this administration is trying to do, particularly in the student loan context. The law says you took out a loan, you have to pay it back. But we're going to say, well, you don't have to pay it back, and you don't have to pay it back, and we're going to pick the criteria of who has to pay it back and who doesn't. That is absolutely forbidden dispensing power, and it's been forbidden since the founding of our country.
Well, it appears they're doing the same thing with the Hunter Biden case. We'll hear some interesting testimony on that today, but I don't want to get too far off the subject here. Okay, so what now? Biden has decided to forgive how much in school loans? What's the actual number?
Gosh, who knows? I mean, the $39 billion was the number that they had said most recently that they sort of quote unquote have already forgiven, in the sense of they have made some promises to folks, but that money hasn't gone out the door yet, or those letters haven't gone out the door yet. So, there may be opportunities to file preliminary injunctions and so forth to prevent that money from going out the door. What I can tell you is that the pause that they've had in place, where they've told people you don't have to make payments and the interest won't accrue against you if you don't make those payments, that is currently costing the country $5 billion a month. And that goes back, and by the way, Congress did pass a law. People want to say that one of the reasons the executive has to act is because Congress won't. No, Congress did pass a law. It was called the CARES Act. They passed it right at the beginning of the pandemic, and they created a 6-month pause on student loan payments between about April and September of 2020. There was a pause in place that Congress approved. Now, that's legal. When Congress does it, it's legal. The problem is that first the Trump administration and then the Biden administration, for all the months since then, since about September of 2020, have kept extending that pause. And again, at a cost of $5 billion a month to the American taxpayer. And that's going on now. And we have a lawsuit in place right now that's ongoing against the pause and trying to stop that.
What about a lawsuit against this $39 billion, which, by the way, will grow to be $40, $50, $60 billion by the time they're done, because they always lie about how much stuff is going to cost. Is that going to be challenged the same way the use of the HEROES Act was challenged all the way up to the Supremes?
I can tell you that we're looking at it. I wouldn't be a bit surprised if other people are looking at it as well. The tricky thing with all these cases is that you have to find a plaintiff with standing to sue. And you saw that even at the Supreme Court, even though the Biden v. Nebraska case came out in favor of the states who were suing, there was another case at the Supreme Court at the same time, Brown v. Department of Education, that was brought by some individuals in Texas. And even though they had won at the lower court level, when it got to the Supreme Court said, no, you don't have standing to bring this lawsuit. And so they lost. So I think everyone's trying to be a little bit careful, dot their I's, cross their T's, make sure that they have a theory of standing that will survive all the way up if necessary.
Okay.
But I do think there will be some lawsuits brought.
Oh, okay. Just so the audience knows, standing means you are an injured party. You can prove that this has impacted you. In other words, if a car dealer screws my next door neighbor, I can't sue the car dealer because I don't have standing. I mean, but my next door neighbor can sue the car dealer. So this issue, you would think the American taxpayer at large would have standing,
Well, and there's been a lot of good conversation about that, because the sort of case that's about 100 years old now that says that there's no such thing as taxpayer standing was dealing with pretty small amounts of money. And the idea is, look, just because as a taxpayer, you distribute this harm over the entire tax-paying base, and maybe it's 20 cents or 50 cents to you, that just isn't enough to provide standing. But when you're talking about forgiving $500 billion in debt, that's real money to every American. And so there are a lot of people who have said, look, we need to rethink this theory of taxpayer standing. If you're talking about sums of money that vast, then people do need to be able to assert a taxpayer standing to oppose it, particularly when the administration has been very clever and very devious about how to design the program to try to stop anyone from having standing. So you may remember early on they said this applied to private loans as well, and then they backed off that really quickly because they realized that the private loan folks were going to have standing to sue over the program, and they didn't want that. So they said, oh, no, never mind. It only applies to the federally provided loans.
Yeah, well, they're pretty slippery. If people could understand the size of $1 trillion, it would just scare them to death. My favorite is this. I don't know if you ever heard this or not. If you were born 1 billion seconds ago, you were born somewhere in the mid to late 1980s. If you were born 1 trillion seconds ago, you were born in the year 29,600 BC.
Oh, wow.
I mean, that really brings it home, does it not?
Yeah, it does.
And
it's a massive amount of money. And the idea, look, what the Supreme Court said in the Biden v. Nebraska case, it applied this major questions doctrine, which has been around for a while, but they finally gave it a name here in one of the recent cases called West Virginia v. EPA. But they applied this and they said, look, if you're going to say that an agency is going to be doing something that's new and that requires vast amounts of power and has a huge impact on the economy the way that this would, then you just can't do that based on some vague statutory authority. You have to have clear authority. Congress has to speak with clarity. We as the court are not going to read into some sort of vague language the power for you to do this. But that's what we've seen over and over again. Jim, you were talking about democracy. What this administration has decided to do is rummage around in old statutes and just look for authority to do whatever it wants to do and pretend it's there without going to Congress. And they were doing that even in the first 2 years of the administration when they controlled the House and the Senate. They're just lazy. They just want to have power without having to have the people vote for anything. And that's not the way our system's set up.
Well, I think what's really going on here is, I said this earlier, it's not really Trump versus Biden. It's not really left versus right anymore. It's a question of who runs the government. Do the people run the government as laid out in the Constitution, or does the administrative state run the government? And when somebody like Trump comes along, who was selected not from the menu that was provided to us, but he came out of nowhere, all of a sudden you see the administrative state. You see people with names you never heard of before, like Strzok and Page and Brennan and all these other people. All of a sudden it is revealed to you that the administrative state thinks it's the country. And anybody who threatens that has to be destroyed.
And that's why the New Civil Liberties Alliance was created, to combat the administrative state. That is what we do all day long. It's the only thing we do. It's our entire focus. And we've had a great deal of success. We had a Supreme Court victory against the Securities and Exchange Commission this year. We've been fighting the student loan battle. We fought against the nationwide eviction moratorium. The kinds of things. If you had told me when we set this group up 6 years ago now, or almost 6 years ago now, that we would be fighting this kind of action by the administrative state or by any administration, I'm not sure I would have believed you, Jim. I mean, these are breathtaking assertions of power that this administration, and in a couple of cases, frankly, the last administration, have asserted. And I think one of the problems we have, one of the problems we saw in the last administration was that you would see some of the administrative state actors do things without permission or against what the White House would have wanted. In the current administration, I fear what we're seeing is that there's no one home at the White House, and so the various administrative agencies are going hog wild, because ordinarily, like let's say under the Obama administration, they might have a few agencies that they would turn loose, whether it's EPA or Environmental Protection Agency or whichever sort of favorite agencies that they wanted to to go forth and conquer. But it wasn't every agency. But under this administration, it doesn't appear that there's anyone who's trying to rein anything in or corral anything. And so you basically have every agency that's out there trying to assert its power to the max. And I'm not sure that our system is equipped to deal with that sort of flooding of the zone by the executive branch. The courts just can't act fast enough to push back against it.
Yeah, well, I think they know this. That's why it's sort of a bureaucratic blitzkrieg. I'm up against a hard break.
Oh, that's a good description.
Yeah, I've got to go. This is the New Civil Liberties Alliance, and you guys are doing great work, and I want to thank you for being on the show today. But like I said, I'm up against the clock, and I hate that. So thank you.
No worries. NCLAlegal.org if people want to find out more.
All right, what is it? NCLA
Legal.org.
Thank you, sir, very much. Thanks for your work. We really appreciate it.